People accused of DWI are always asking, can I beat this charge? And it's impossible for me or any lawyer to answer that question without speaking to you and reviewing the evidence in your case. In this video, I'm going to try and provide a few of the common defenses to DWI that are used most often and that have the best chance of success. To understand what the DWI defenses are, we have to understand first what the state must prove in order to gain a conviction. There's two ways the state can gain a conviction in a DWI case. The first one is what they call a per se case, which means that if after a blood test or a breath test, your blood alcohol concentration is 0.08 or higher, you're automatically considered to have been intoxicated, and that's all the state needs to show in order to gain a conviction. The second way is if the state can't establish your blood alcohol content is 0.08 or higher, they can prove their case by what's called observation, meaning what the police officers saw. Things such as a pattern of driving, your physical appearance, and field sobriety testing. Defending successfully against the DWI charge means defending against both of the state's options for gaining a conviction. So defenses that can overcome both of those cases are the best options. The first such defense would be if there was an illegal stop of the motor vehicle. The police have to have an articulable suspicion. They have to have a reason for stopping a car. And if they don't have a reason, then everything they saw and all the evidence they've gathered after that would be inadmissible at trial. That would be a defense to both ways that the state can prove a DWI. Another such defense that would defend against both cases is operation. The state has to prove that you were actually driving the car or that you intended to drive the car while you were intoxicated. If, for instance, you were sleeping in the car, you may have a defense that you were not actually driving and that you didn't intend to drive the car. There could be other circumstances where operation would be at issue, meaning if you were not in the car when the police found you and maybe somebody else was driving the car. These would be defenses that overcome both of the state's cases. Is necessity, meaning that yes, you drove drunk, but you had to do it in order to avoid a greater harm. An example of this would be if you were being assaulted or about to be robbed, physically harmed, and so you got in your car and drove away to avoid that harm. Another example would be if you were trying to save somebody else was being assaulted, and the only way you could help them, get them to a hospital or something, was to get them in your car and to drive. This is a very rare and very difficult defense, but it is always an option, or it can be an option for some people. The next consideration would be defending each of the state's cases individually. So we can start with how do you defend against the per se case, the 0.08 blood alcohol content. One of the defenses would be an illegal arrest. After the police stop your car, they have to develop what's called probable cause, meaning that it's more likely than not that you are intoxicated before they arrest you. If they can't develop that probable cause based on what they saw and what you did and the field sobriety testing, then the results of the breath test or the blood test taken after that illegal arrest would be inadmissible at court. Another defense that attacks the per se case is machine errors. Machines are not perfect, and they make mistakes. And in defending a DWI, we obtain all the records of the case, the certifications of the machine, the downloads of the data that the machine is performing, and we evaluate those cases for any mistakes that might show the machine is unreliable. If the machine is unreliable in your case, the result of the breath test would be inadmissible. For a blood case, the police must follow very specific protocols in drawing the blood, storing the blood, transporting the blood, and if they make a mistake in any of those points, the result of the test would be inadmissible in court. So we review all of those aspects as well. Lastly are police procedural errors. They must observe you before giving you a breath test for 20 minutes. They have to give you very specific instructions in everything that they do and ask you to do. If they make any mistakes in any of these required procedural areas, it could result in having the results of the test deemed inadmissible and not being able to be used against you in court. Lastly, if you do overcome the per se case against you, you still have to overcome the observation case against you, the police observations, what they saw you doing, how you were driving, how you performed on the field sobriety tests. This is a very fact-sensitive situation. We have to look at everything the police did, the exact details, the height, distance, movement of everything. Often we need to bring in expert witnesses to contradict the police testimony in order to do this. But it is a defense that does work and is necessary. And when you're sitting there asking yourself, can I beat this case? The answer is there's always a chance. The only way to get your answer is to call and discuss your DWI case with me today.